Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This video will be useful for the CPC students because we are going to deal with section 47 of the Civil Procedure Code. Honorable Justices Sanjay Kishan Kaul and Sudhanshu Dhulia of the Honorable Supreme Court, in the case of Pradeep Mehra versus Harjivan J. Jithwa in Civil Appeal number 6375 by 2023, dated yesterday, that is on 31st October 2023, held that Section 47 CPC stipulates that the executing court can consider only questions relating to the execution, satisfaction, dissatisfaction of a decree, but not validity. Not validity of the decree. Yes. Now, let us have a cursory reading of section 47 of the CPC. Section 47 says, questions to be determined by the executing court. Executing court. All questions arising between the parties regarding execution, discharge, satisfaction of the decree shall be determined by the court executing the decree. So maybe the transferee court also. Suppose if the decree is transferred to another court, that court also can answer all these questions. The important point is they can answer the questions relating to the satisfaction, discharge or execution of the decree, but not validity of the decree. This you have to remember, because the entire case revolves around the validity of the decree. Right. Now let us go to the facts of the case. This is a case under Rent Control Act. Right. A civil application or OS was filed for eviction of the tenants by the landlord. That is already I told the case appellant, he is Mr. Pradeep Mehra against Harjivan, Jithwa and others. He has instituted a civil suit against them for their rent control and also eviction. During the process of the trial, both of them effected compromise. This petitioner is aged about 70 years. Now they have come to a sort of compromise. The compromise is that they will settle the rents within 2 months. If not, he can occupy the shops. Therefore, consent decree was given like that. Both of them approached, you all know what is consent decree, approached the court. The terms and conditions were informed to the court. Honorable court was pleased to pass a consent decree stating that if the parties do not pay the rent within the 2 months, yes, he can occupy the same. Same thing happened. They did not pay the rent. They failed to pay the rent. Ultimately, he has filed an execution petition under Order 21 of the CPC. Execution petition for the eviction of those people. Now the trouble started. In the beginning of the judgment, Honorable Justice Sanjay Kishan Kaul sir said, the PV Council, please remember, Privy Council in some case, I don't know, I remember that case, they stated that the real trouble, please remember, that real trouble for a litigant starts from the step of execution. Even though the judgment comes in favor, decree comes in favor, but he faces the trouble from the execution petition. That's why I told you, Order 21 rule, it has got 106 rules, entire CPC can be rewinded once again with the help of the so-called execution petition. Right? Now, the very important point is, please remember, section 47, as well as you have to read Order 21 also. I told you a number of occasions in the class also. the questions relating to the execution, other things, they have to be decided by the executing court. Right. Now, he has filed the execution petition and they questioned. So, actually, he has filed an executive petition under 21 of the CPC. Then the trial court, yes, they have given the EP and asked him to take position and asked them to evict. But will they keep quiet? No. So this happened in the year 2013. Now they have gone against the execution petition. Please remember, and they filed a questionnaire before the court regarding the validity of the decree. Right? So even though it is a compromise decree, even though the trial court stated that it can be executed, but the tenants filed an application under 47 objecting the palatability or validity of the execution petition. Yes, in 2013, the court, the trial court, the executing court dismissed their application, stated that you have to evict or you have to vacate. Then, please remember, these people approached the High Court. What did the High Court do? High Court in the second appeal, they have asked the trial court to relook the matter and they have allowed the appeal, stating that how this is maintainable. So, once again the trouble started. Therefore, the matter has come to the Supreme Court. Honorable Supreme Court of India, basing on the case of Rahul S. Shah versus Jitendra Kumar Gandhi and others 2021. Please remember, there the Supreme Court lamented on the snail's pace in execution of the decrees. And please remember, the important point is the validity of the decree cannot be questioned, cannot be entertained by the trial court. Decree is already decided. It is moreover it is a compromise decree. Then you cannot question the decree, the point validity of the decree as an application. No doubt, if you are having any grounds, you can go for appeal. But here it is a compromise decree. You can't go for appeal. It is one way or other protracting the process. That's all. So Supreme Court clearly stated that the executing court need not answer the application. The High Court also is not correct in entertaining his application. So they have to vacate. Right? This is a beautiful case law on section 47. So ultimately you have to remember that section 47 deals with the execution, discharge or satisfaction of the decree, but not validity of the decree. If you remember this much, it is sufficient. Thank you.